I want to welcome you all again. My name is Kara Birdfair. I'm a Senior Fair Employment and Housing Counsel at the California Civil Rights Department. I'm going to let my colleague Taylor introduce herself in a minute, but thank you for joining us. This is Fair Housing and Survivors of Gender-Based Violence and Elder and Dependent Adult Abuse. Just a disclaimer, our little legal disclaimer, this guidance is just for informational purposes. We're not establishing policy rights. We're not giving you legal advice. And the opinions expressed by the presenters don't necessarily reflect the opinions of the presenters, CRD, and the Family Violence Appellate Project. And just a few things before we start. The webinar is being recorded, and we will send a link to the recording when it's posted. We will put a link to the slides in the chat. It may already be there. The chat is otherwise disabled, but you can ask questions through the Q&A feature. We just find it to be much easier to manage the questions if they're through the Q&A. And MCLE credit is available. We're going to put a link in the chat about 10 minutes before we end. And I'm going to hand it over to my colleague, Taylor.
Hi, everyone. My name is Taylor Campion. I go by she, hers. I'm at Family Violence Appellate Project, which is a statewide support center, which means we answer questions for, I'll tell you more about us in a second. So I'm going to start with the introduction of FAP, and then Kara's going to go. And Kara's then going to talk about fair housing, and then I will go on to more specifically about housing with respect to survivors of gender-based violence and elder and dependent adult abuse. Next slide. So FAP introduction, part 1. Next slide. So I come from FAP, and we are, as I said, a legal aid support center dedicated to serving survivors of domestic violence in California and the state of Washington. We represent survivors in civil appeals for free, and we provide free legal trainings and legal support and technical assistance to shelters, advocates, and attorneys representing survivors in trial courts, including self-help tools and online training tools. And at the end of this presentation, I'll give you a link to where y'all can find that, because we have a ton of resources on our website. Next slide, please.
All right, I'm gonna take over for a moment. So as I'm sure you've noticed, DFVH has changed our name. We are now the California Civil Rights Department. This change happened as of July 1st. Why do we change our name? Generally it just better reflects the work that we do. We don't just do housing and employment. We do work around assisting people who are survivors of hate violence, human trafficking, and many other civil rights issues. And, we also saw it as a barrier because people thought, with our name being just mentioning fair employment and housing, it really made people think that our scope was limited to that. So we are now the California Civil Rights Department. All right, and a little bit about DFVH. So again, the mission of CRD, not DFVH, I'm still getting used to it, is California Civil Rights Agency. And our mission is really just to protect the people of California from unlawful discrimination, public accommodations, and hate violence and human trafficking. And I'm going to take a sip of my water. Okay. All right, CRD responsibilities. We investigate discrimination complaints. We facilitate mediation. We enforce the laws by prosecuting violations in court, and we engage in public outreach and education. I apologize. I am getting over a terrible cold. Fair housing laws enforced by CRD. We have the Fair Employment and Housing Act, and this protects people from both housing and employment discrimination. We enforce laws that don't allow you to take state funding if you engage in discrimination. I'm actually going to hand these slides over to my colleague Taylor because I cannot stop. My throat is really bothering me and I don't want to cough through the whole presentation. So Taylor, would you mind reading the next couple slides? I apologize to everyone on the.
Not at all. And I see there's questions in the question and answer about the access to the slides. So other Taylor, who's on the line from CRD or CARA, if you could, because I have no idea. The Unruh Civil Rights Act protects individuals from discrimination/harassment by business establishments. And this can include landlords where it applies to most housing and where housing advocates will see it the most, but also stores and restaurants and those other public accommodations, which are more obvious. And also Disabled Persons Act, which is Civil Code 54, and gives individuals with disabilities or medical conditions the same rights as the general public to the full and free use of all public places that include streets, highways, sidewalks, etc. So similar to California, kind of like California's version of the ADA. Next slide, please. And then here are different characteristics that are protected in housing. As you can see, it is a long list, and these mean your landlord or other housing providers can't treat you differently because of your membership or your characteristics listed on this. I can see there's questions about Spanish subtitles. I have no idea how to do that. I know it's an option.
We're working on it behind the scenes.
Okay, it's being worked on. Thank you. And some ones I'd like to highlight for here, just because we're talking about gender-based violence, is sex and gender. Although it specifically doesn't say survivors of domestic violence, these, because these are characterized protected classes, sex and gender, and most survivors are women. Having these as protected characteristics can help survivors of domestic violence and discrimination. Okay, next slide, please. And some other protective characteristics are disability, military or veteran status, genetic information, primary language, immigration status, age, and citizenship. And the ones that are asterisks, so and the ones in red, are only under the Unruh Civil Rights Act, but that applies to most housing accommodations. And it may not apply if you're, renting from one single person to rent a room, but generally it would apply to most housing situations. Next slide, please. Okay. These are my slides, so I feel more comfortable now. Okay, so representing survivors of housing legal issues. Next slide, please. And I am first going to just kind of list out the laws and then talk more specifically about what they do. So I'm not expecting you to get a lot of information from the next few slides, just so if you have a reference to them when you go back and want to look at this information. All the laws I talk about are just listed right here. So first we have state laws protecting survivors' housing, and this is Family Code. This is also called the DVPA, and this provides survivors avenue to remove abusers from their homes and to require their abusers continue to pay the mortgage or rent during a duration of a restraining order. You have the California Civil Code and California Code of Civil Procedure, and this is the bulk of like the eviction protections and lock changes that you will talk about in more detail. And then you have the California Government Code, and this allows survivors to make their addresses confidential and prohibits ordinances from penalizing survivors or their landlords because law enforcement is called for assistance. Next slide, please. And California Government Code, so this is FEHA. This is one of the things we just talked about. So that is the code that protects people because of their protected classes, which are listed above in the previous slides. Then we have the California Health and Safety Code, and this requires housing authorities to report tenancy terminations and termination notices given to domestic violence survivors to the California Department of Housing and Community Development, and also the California Welfare and Institution Code. And this provides additional assistance under CalWORKS if the assistance is needed because of domestic violence. Next slide, please. And then federally, we are going to talk about VAWA, which is the Violence Against Women's Act. And this provides survivors living in certain subsidized housing protections by making it illegal for them to be denied housing because they're a survivor of domestic violence, sexual assault, dating violence, and stalking, and terminate housing of these survivors or otherwise punish them because they're survivors. And then we have the Fair Housing Act, which is the federal version of the of FEHA, so California's Fair Employment and Housing Act that we already talked about. And I haven't mentioned this before because I usually do it at the beginning, but I love questions. And so please, if you have any questions, do not shy away from putting in the chat or raising your hand or however this platform works, because it makes everything just better for everyone. There are no stupid questions. Next slide, please. Okay, so those laws I just mentioned, I'm going to teach you about them by applying them to two separate couples. One is Rory and Jules, and Rory and Jules live in private, non-subsidized housing. And the next is Morgan and Jordan, and they live together with Jordan's Section 8 voucher. Next slide, please. So first I'm going to talk about Rory. Rory is a survivor of domestic violence. Rory rents an apartment with her partner, Jules. Jules abuses Rory, and Rory and Jules are 6 months into a one-year lease. Next slide, please. Rory is ready to leave Jules. Will Rory be liable for rent if they move out? Next slide. No, this is because they can end their lease early under Civil Code 1946.7. So this allows a survivor of domestic violence, dating violence, sexual assault, stalking, human trafficking, elder or dependent adult abuse, and human trafficking and sexual assault. Yes, I said them all. Plus survivors of violent crimes to end their lease early. All they have to do is provide their landlord a copy of a restraining order or protective order issued in the last 180 days, a police report no older than 180 days old, a statement from a qualified third party, or any other document that reasonably verifies the abuse occurred. And once they do that, they only have to pay 14 days rent after giving the notice. So here, Rory was in the middle of a one-year lease, and so Rory would not be obligated to the rest of the lease, only be obligated to pay those up to 14 days from after they gave the notice. Next slide, please. So who is a qualified third party? Is it a licensed doctor, nurse, or psychologist, a clinical social worker, a licensed marriage and family therapist, a DV counselor, sexual assault counselor, or human trafficking caseworker, victim of violent crime advocate, or all of the above? I think you guys would all get this one, but next slide, please. It is all of the above. So a lot of folks can be a person to provide documentation to show that person is a survivor. I'm sure some of you folks on this call yourselves can be one of those people that do that. FAC has a toolkit that has template letters that survivors can use to break their lease early, along with template letters that the people listed on this can use to verify someone is a survivor to let them break their lease early. And again, the information about where to find those forms and stuff is going to be available on the next page. And I see a question, isn't Jules still liable for the rest of the lease? Yes, the answer is yes. Jules would still be liable for the rest of the lease. Rory, however, would not be. This is fairly common where a survivor is sharing a lease with the person that's harming them and moves out. If the survivor does not do this early lease termination, which unfortunately happens often because they're in crises, they don't understand, they don't know the law, they just move out, and then maybe the abuser stops paying, or they move out too, and so then the landlord may try to come after the survivor for that rent, even though they left before the other person was still there. And because generally tenants are jointly, so together they owe all the rent, but also separately they can both liable for all the rent. It's really important that even when you were living with the person who harmed you and you are ending that lease early, that you do that early lease termination to make sure you're not liable if they stop paying the rent, which can be a way to exert power and control over the survivor. So it happens, unfortunately, fairly frequently. And some security deposits. So Rory's security deposit should be returned as usual, no longer than 21 days after I move out, with an itemized list of any deductions. Because Rory is living with Jules, as I mentioned before, unless the security deposit was specifically paid for Rory and said so on the lease, it may be difficult to get that back from the landlord, in which case Rory could try to go into small claims to get it from Jules since they ended the lease early. There are different options, and my suggestion usually is to try to work with the landlord to see what would work best for you, and to try to get that back. If you need money for a new security deposit, domestic violence agencies sometimes have housing first funds or other funds that are able to assist with security deposit when you have to move because of domestic violence. But again, not always, but that is sometimes an option for survivors who have to move and need help with the security deposit money. Next slide, please. So Rory is looking for new housing and has a criminal history because they experienced domestic violence from Jules. Can a private landlord deny Rory's housing application because Rory has criminal history? Yes, no, maybe. I would love to see people's answers in the chat.
We can actually put this up as a poll.
Oh, cool.
Yeah. Other Taylor, can you put up, it's the second poll, starting with Rory, if we're able. And so we'll give folks a few minutes or a few seconds to answer. And then if you could put up the answer when we have a critical mass.
And I see Victoria has a question about that health and safety code in the question and answer. I can reach out to you after the presentation since we've kind of passed that. I'm not going to be getting back to it. I would, and you have a lot of parts to your question. I can reach out to you after, Victoria. So I see the poll has come in, and the answer is yes, no, and maybe. And about a little less than half of you are correct. So you want to go to the next one, please? Yes. Maybe because. Next slide, please. So a landlord cannot automatically deny an applicant with criminal history, but must consider the applicant's specific criminal history, including information that shows the person is not at risk for the health and safety of other tenants or properties. So this is in the California Code of Regulations, which is the regulations that administer the FEHA, so the California Fair Housing and Employment Act. In it, they specifically talk about domestic violence. So conduct arising from an individual's status as a survivor of domestic violence, sexual assault, dating violence, stalking, or comparable offenses against the individual is mitigating information that helps suggest the individual does not pose at risk. I strongly suggest that this would also apply to survivors of human trafficking and other survivors of any gender-based violence not listed here. because and elder and dependent adult abuse, because they're similar in nature with the power and control. And in here, in Rory's specific case, their criminal history result of them being a survivor. So Rory can show they're not a risk to the property or other tenants. It unfortunately is not uncommon for survivors to get arrested when the police are called for assistance, or even get restraining orders against them because their abuser went and filed as a way to punish them or exert power control. So this is very helpful for survivors who are looking for housing. Next slide, please. Okay, so can you please provide examples of criminal history as a result of domestic violence as a survivor? So as apart from what I just said about getting arrested because the police think you are the culprit, it's not. So if we're talking about domestic violence charges, we're not just talking about domestic violence charges, which can be, but they can be other instances. For example, maybe your partner refused to, help, said, if you don't go steal this one thing, I'm going to do whatever. And so you do that for the partner because they're doing power control. Just criminal activity, it can be part of a pattern of control over that person. Survivors are not uncommonly arrested, as I said before, but so like theft is not uncommon. Kind of those kind of charges related to noise, sometimes drug charges can be a result of domestic violence. Does that answer your question? I am not, okay, thank you. I think so, I'm not as good with these. Yes, thank you, okay, great. So here Rory decides to live with family. So they live in a house with their aunt, grandmother, and the lease is Rory's aunt's name, and the landlord approves Rory's move. Next question, next slide. Unfortunately, Jules has a key to the house. Can Rory change the locks? Next slide, please. Yes. So to change the locks here, Rory must write to their landlord and request a locks change, provide the landlord a copy of the restraining order or police report, and they both, either of which must have been issued in the last 180 days. And after receiving the restraining or after receiving the restraining order, the landlord must change the locks within 24 hours or police report. If they do not, the survivor can change the locks themselves, but they do have to provide a key to the landlord. This also applies if, say, you are a survivor who lives with a person who harms you, but you get a restraining order with a move-out order. You can still have the landlord change the locks, even though the person was on the lease, but you have to have a restraining order with a move-out order. That is, so it applies both when the survivor lives with the person or does not live with the person. But there's different requirements depending on the situation. If the landlord is arguing that the survivor should pay for them, there's good arguments that the landlord themselves is the one responsible for paying for it. That is specifically because the law puts the duty on the landlord to change the locks, and the California Apartments Association, which is the organization that supports landlords and their rights, in their informational videos, they actually say the landlord should pay for it. So hopefully your landlord or whomever you're working with landlord will pay for it. But if they don't, please reach out and we can see if we can give you a template letter for them to help so the landlord can do that. And also if they don't, the California Victim Compensation Board does offer up to $1,000 for enhanced security of your home And so that is another way that a survivor could apply for money if the landlord won't pay for that through the Victim Compensation Board.
Hey, Taylor, we have a question on this topic. So are there any options for survivors who want to request a lock change but are not pursuing a restraining order, police, or criminal legal options?
Unfortunately, this law has not been updated for quite some time. So the only way to get the locks changed, where the landlord has to do it, is with a restraining order or a police report. This is the only California code that has that. For the TRO, a TRO should work for getting the locks changed when the person does not live with you. If there's a move out order in that TRO, I believe it should work as well. I would have to double check, but it does need to have that move out order. But because TROs should in theory be fairly short. They only have, once that time period ends, the landlord would have to, grant access back to the person because it isn't an eviction. But the permanent restraining orders, because they last for a long time, in theory, should have someone at least out for the next few years. The person doesn't evict them. It just kicks them out for the duration of the restraining order period. Does that answer your questions?
Sounds like it, yes.
Okay, great. Next slide, please. Okay, so unfortunately, Jules then goes to Rory's home and assaults Rory. Rory's family calls 911. The police show up and arrest Jules. A neighbor calls Rory's landlord, complains about noise from the incident, and claims Rory is ruining the neighborhood. Next slide, please. So a few days later, the landlord gives Rory's family a 60-day notice claiming they created a nuisance by disturbing other tenants and the night Rory was assaulted. Does Rory have any defenses for this eviction? Next slide, please. Yes, they have two defenses. First, the right not to be evicted for needing law enforcement or emergency assistance. And second, the right not to be evicted because you experience acts of abuse. And I'll talk about these a little more. Next slide, please. Oh, next slide, please. So first affirmative defense is that the landlord is not allowed to evict Rory for needing help from law enforcement. So a landlord is not allowed to evict, punish, threaten to evict, or punish a tenant because emergency assistance or law enforcement was called when the tenant experienced sexual assault, domestic violence, stalking, human trafficking, or elder or dependent adult abuse, or the tenant was the victim of a crime, or the tenant was experiencing an emergency. For example, they're having a heart attack or someone's breaking into their home. Or the tenant called for emergency assistance because they believe someone else was being abused, victimized, or experiencing an emergency. Additionally, local public agencies like cities, housing authorities, counties are not allowed to punish tenants or landlords because law enforcement or emergency assistance come to a property for someone who's a victim of abuse, a victim of a crime, or an emergency. These are often called nuisance ordinances or crime-free ordinances, and unfortunately they have a disparate impact not just on survivors of gender-based violence and victims of crime, but also just on communities of color in general, because people are more likely to call the cops on someone who is not white. So there's really big push in California to get rid of all these ordinances because they don't keep people safe. They just get people unhoused because they were profiled or a victim of crime or abuse. There's a question in the chat from Victoria about would it be appropriate to reach out to CDR if someone was not filing 1161.3 and is seeking to evict someone because of nuisance or abuse. So that would be a question for Kara.
I think I would encourage you to reach out to CRD. I think, there's likely a fair housing component here, and that it would probably, result in a discriminatory impact as Taylor was talking about. So, I would feel free to reach out to us. This is definitely an issue that we're trying to focus more on, and I'm glad Taylor brought it up in this presentation. So, thank you.
Okay, next slide, please. So the next is the affirmative dissent. Oops, went too far. Back one slide, please, Kara. There we go. Thank you. So landlord is not allowed to evict for experiencing abuse. So a landlord is not allowed to evict a tenant or refuse to renew a tenancy because the tenant or their household member experienced domestic violence, sexual assault, stalking, human trafficking, or elder or dependent adult abuse by someone who does not currently live with them. And the tenant gives the landlord documentation showing they are a survivor, and the tenant does not allow the person who committed abuse back onto the property, and the landlord does not reasonably believe the person who committed the abuse poses a physical threat to other tenants or the right to quietly possess their unit. So as you can see, there's a lot of ands. So this is not the strongest eviction defense, but I will talk in a few slides about how this is changing starting January 1st because of a great new law that strengthens this eviction defense a lot. Next slide, please. So to receive this defense, as I mentioned in the last slide, Rory needs to give their landlord documentation showing they are a survivor. And that can be a police report, a restraining or protective order, or a letter from a qualified third party. So that is the same qualified third parties that I mentioned previously: doctors, domestic violence counselor, therapists, and that letter would confirm that Rory sought assistance for physical or mental injuries or abuse. We have a template that qualified third parties can use to help a tenant assert this defense. So you can find that on our website and have more information about on the next page. Next slide, please. So in Rory's case, Rory's landlord rescinds the 60-day notice because with help from an advocate, Rory writes their landlord a letter explaining why Rory cannot be evicted because they experienced abuse and needed police assistance. Rory keeps a copy of the letter for their records, and landlord responds to Rory's letter by telling them they rescinded the 60-day notice. Oftentimes, just sending a letter to a landlord saying, hey, you're not going to succeed in an eviction, will stop the eviction. Evictions can cost a lot of money, and if a landlord doesn't think they're going to win, they're going to be a lot less likely to move forward with that eviction because they don't want to be out a lot of money for nothing. So that is always, in my opinion, a great first step because that can stop a lot of evictions from moving forward. Next slide, please. So after the landlord rescinds the notice, Jules shows up at Rory's unit and threatens to hurt Rory if Rory does not let them in. Rory lets Jules inside. Landlord sees Jules enter Rory's unit with Rory, and the landlord serves Rory and the family a 3-day notice to quit. Next slide, please. Can they still use this defense? Next slide, please. Yes. This is because the act of showing up to the unit itself was domestic violence. And there is a lot of case law that supports this. And also, Rory did not have a choice in allowing Jules to enter the unit. Denying Jules entry could have resulted in harm to Rory or their family. If someone says, if you don't do this, I'm going to shoot you, you're not voluntarily letting someone in. You are being required or coerced to let them in. So this is a case that would be one that definitely would be really helpful to have an attorney with who can argue this well, because there would be some education to the court often required to explain why this law should still apply, but it should definitely still apply. Next slide, please. However, starting January 1st, it won't really matter as much because the law is getting so much better. So this is because of SB 1017, which FAP, so myself and Western Center Law on Poverty and California Partnership to End Acts of Violence, California, or Crime Survivors Against Safety and Justice, and CUAV were all co-sponsors. And this bill significantly increases the affirmative defense to survivors under 1161.3. So starting January 1st, a landlord is not allowed to evict a tenant or refuse to renew a tenancy because the tenant or their household member or their immediate family member is a victim of domestic violence, sexual assault, stalking, human trafficking, elder or dependent adult abuse, or violent crime. And the tenant gives landlord documentation showing they're a survivor, they can't get evicted. So there's so much less caveats. The one big caveat is the tenant does lose this defense if, after they get a 3-day notice banning the person who harmed them from the property, the tenant allows the person back onto the property and the person threatens other tenants or guests' physical safety. So no longer is there a requirement that after that happens, the abuser never comes on the property for any reason. They just have to not come on and not threaten anyone else. This takes care of some huge loopholes that made it so a lot of survivors weren't able to get this eviction defense because just normal life. Oftentimes you have kids with the people who harm you. And so even if you get a notice, they still have to come pick up the kids, or the person comes on the property as a way to exert power control and is really, really loud, and then you get evicted, even though you're not inviting them back. But starting January 1st, the law will change and it'll be so much better. And also two other big, really important changes to the law is there are now partial evictions. So if you live with a person who harms you and you're getting evicted because of abuse, you can still assert this eviction defense. And if you get the defense, the court will issue a partial eviction. So this will remove only the abusive party from the unit. And so you would get to continue your tenancy, and the person who abused would just be kicked out of the unit and no longer be a tenant. So that is a huge, huge change. And another change is their documentation. It now allows you to document that you're a survivor with any documentation or evidence that reasonably verifies the violence or abuse occurred. So again, this starts January 1st, and there'll be more training information coming out on that when that starts. But just as a heads up. Okay, next slide, please. Okay, so we will be moving on to federal housing protections by talking about Morgan and Jordan. So Morgan and Jordan have a private landlord and use Jordan Section 8 housing choice voucher. Morgan is on Jordan's vouchers as Jordan's partner, and they've lived together for 2 years. Next slide, please. So Jordan's Section 8 voucher gives all household members legal check protections under VAWA. And here are the list of all the housing providers covered under VAWA. That just expanded starting October 1st because the new VAWA. And there also is a new catch-all provision that subjects most every federal housing program to VAWA. But if you are in one of those federal fair housing programs and it's not listed here, or you're advocating for someone there, I would reach out to see how to advocate to make sure the person is covered by VAWA. Next slide, please. So this is what VAWA does. It protects covered housing providers from discriminating against or evicting survivors of domestic violence, dating violence, sexual assault, or stalking because they are a survivor. It requires tenants receive notice of VAWA protections. It requires housing providers keep tenant status as a domestic violence survivor confidential. It requires that survivors have access to emergency transfer plans when they need to move because of abuse, and requires housing providers to bifurcate or split, or not requires, allows. I wish it requires. It allows housing providers to bifurcate or split a survivor's lease, ending the abuser's tenancy and allowing the survivor to stay. With the new law, SB 1017, that will be a lot easier in California. So that's exciting. And we have more information about this in one of our toolkits information sheets, which again, I'll give you a link to at the end of the slide. Next slide, please. So all the laws that protect Worry protect Morgan. So everything I've already talked about also protect tenants that are living in federally fair housing, federal housing in California. They're just extra protected with FAWA as well. Next slide, please. So Jordan physically abuses Morgan. Morgan has to choose if they want to stay in the unit or leave to find a new place. Next slide, please. Okay, so if Morgan wants to stay, they could ask the landlord to bifurcate the lease. Under VAWA, the landlord may choose to end Jordan's tenancy, but not Morgan's tenancy. By evicting only Jordan, bifurcates the lease and lets Morgan stay. How that would work would be filing for eviction and then having Morgan exert the defense. So it's not that clean, but it could happen more often now than it could before, because the court would be deciding, not the landlord, really. But yes, so that is kind of how it happens. Next slide, please. So lease bifurcation. A covered housing program may, but is not required to bifurcate a lease when to allow the survivor to stay in the unit while terminating the person who caused the harm, lease, or assistance. Once the lease is bifurcated, the housing provider must give the survivor reasonable time to either establish eligibility for the current housing program, establish eligibility for another covered housing program, or find different housing. So this is going to be more helpful to folks that are in like public housing or a federal housing provider that has multiple units and has some available, in which case they would then maybe move without having, so they wouldn't have to go through the eviction process, allow one to move to the other unit or something along those lines. Next slide, please. But say the landlord's bifurcated the lease, Jordan leaves. How can Morgan afford the rent without Jordan's Section 8 voucher? For those who are unaware, the way vouchers work is the housing authority pays a portion of the rent to the landlord, and that portion is based off your income. And so if you no longer have a voucher, your rent could go up a lot. So say your rent was $2,000, but 30% of your income was $300, and so you'd only be paying $300 in rent, and the housing authority would be paying the rest. So without the voucher, it could make your rent go up a ton. So how can Morgan afford the rent without the voucher? Next slide, please. By becoming a Section 8 voucher holder. Because Jordan is the voucher holder, the housing authority must provide Morgan the opportunities to obtain the Section 8 housing choice voucher. When a household is using a Section 8 voucher breaks up because of domestic violence, stalking, sexual assault, or dating violence, the housing authority must ensure the survivor attains assistance. This is something housing authorities are not great at, but it's something they have to do. So if you have a client or yourself are dealing with this, please feel free to reach out to see if we can help you advocate with your housing authority. Next question, next slide, please. So Morgan decides to move. And so Morgan uses the housing authority's emergency transfer plan to move without providing 30-day notice and request support to a different housing authority. So a great thing about housing vouchers is you can move throughout the country with them. You are housing choice vouchers, that is. You are stuck at whatever housing authority you are currently at. You are in theory able to move around the country. That's just called porting. To explain that, next slide, please. So every covered housing provider must have an emergency transfer plan that allows survivors of domestic violence, sexual assault, dating violence, and stalking transfer to a different safe and available unit when that assistance has assistance under the covered housing program if the survivor asks for the emergency transfer plan and reasonably believes there is threat of imminent harm from further violence if they stay in the unit, or is a survivor of sexual assault and the sexual assault happened on the premises no more than 90 days ago. The covered housing provider may require the survivor to provide documentation showing they're a survivor. Next slide, please. So Morgan gives the housing authority a written statement where Morgan certifies that they are a survivor. Next slide, please. True or false, the housing authority may require Morgan to produce either a qualified third-party statement as a police report or restraining order, or prove Morgan qualified for VAWA protections. Okay, I think we've had enough time. True. Luckily, you guys are actually mostly wrong. Next slide, please. False, because they can also allow for self-certified statement as an acceptable one. VAWA has better documentation requirements in California. So a self-certified statement is one of the four the survivor can give the housing provider. However, the housing provider can require proof of additional self-certification if there's conflicting evidence. For example, if the other party also says they're a survivor, or maybe the person was arrested because of domestic violence, they may make someone show that they are the survivor with more documentation from that. And I see there's a question in the chat: how would Morgan go about asking the housing authority for this Section 8 housing choice voucher? Generally, it would just be contacting their caseworker. So every voucher holder has a caseworker. So that would be, Jordan's, and kind of explain that they're moving and that they're the survivor and the voucher should stay with them. The housing authority should, let the voucher stay with Morgan, or split the voucher and give two. The reason it comes up with such problems is oftentimes the housing authority doesn't think they have the funds to provide another voucher for someone. And so they would have to go about terminating Jordan's voucher to be able to give it to Morgan. There's advocacy that can be done around that to make sure Morgan can keep the voucher, and education as well to the housing authority about their obligations to provide the voucher to the survivor when the breakup is because of domestic violence. Does that answer the question? Yes, okay. And how does this apply to undocumented survivors? Well, it depends. So this particular is talking about, I'm particularly right now talking about housing choice vouchers, which are only available to people with certain immigration statuses. There are some federally subsidized housing that is covered by VAWA and is open to people of all immigration statuses. The most common is low-income housing tax credit properties. They are federally subsidized through the IRS and have below market rate housing, essentially, is what it is. And those are available to undocumented survivors. But unfortunately, a lot of the federally subsidized housing, such as housing choice vouchers, are not available to undocumented survivors. Next slide, please. So we're reaching the last few minutes. We have 8 minutes left. And so I would like to end this with a kind of a case study. So what I'm going to do is I'm going to read this and then give everyone a minute, because we don't have that much time, to kind of think about their answers, and then I will go through my answers about what to do in this situation. So here, Dottie has a Section 8 voucher and lives in a low-income housing tax credit property. That's the LIHTC. And Momo is not on the lease and physically abuses Dottie. Against Dottie's wishes, Momo made a key to the apartment and comes and goes as he pleases, usually spending the night. A neighbor called the police during a fight. Even though Momo was the aggressor, both were arrested. After the incident, Dottie's landlord issues a notice to terminate tenancy for nuisance and having unauthorized occupant. And the housing authority sends Dottie a notice stating that they are terminating her voucher because of an unreported household member and engaging in criminal activity. Unfortunately, this is not that weird of a scenario, and it's fairly common fact scenario. So take a minute. I will talk again at 55. So I guess 2 minutes to think about what you would do. Okay, so I kind of split. Oh, next slide, please, Kara. So first, I'm going to talk about the notice to terminate tenancy, because that's the first section, kind of not as much of the VAWA stuff, but still some. So first, what Dottie could do was write a letter to the landlord demanding they rescind, like cancel the notice, because they're terminating her tenancy because of calls for law enforcement, which is against the law. They're terminating her tenancy for acts of abuse by a non-tenant. And their tenancy because of abuse. She lives in a low-income housing tax property. And so that property has to follow VAWA. And the strongest eviction defense is for being evicted because of abuse, is if you live in a VAWA covered property. Even with the new 101161.3, I would argue that VAWA is still a stronger eviction defense if you are covered by it. So they can't terminate her assistance because of abuse. So that is the first thing that I would do. Next page, please. And also consider affirmative litigation. VAWA does not explicitly provide for a right for an affirmative lawsuit, but HUD recognized the relationship between VAWA and the Fair Housing Act. So Kara and I actually together many years ago had a client who was getting evicted because of domestic violence. And we did a demand letter to the landlord's attorney, and they were still moving forward. We called the office, we're still moving forward. We're like, okay, we're gonna file. So we wrote up the complaint. The day before we filed, we called them one more time. It was like, hey, we're about to file this. You violated VAWA, you violated UNRU. We're filing this. And the next day, the eviction was thrown out. So affirmative litigation can very much stop evictions. Next slide, please. And that was before we were at our prospective employers. That was when we were at Law Foundation down in Santa Clara County. And also if the landlord files an unlawful detainer, assert all of the defenses I listed on number 1. And also, if they did not give those VAWA notifications when they gave that notice, if they're terminate the tenancy, there is great case law thanks to Liz Nick, Legal Services from Northern California, that states if you are filed by VAWA, you can't move forward with the eviction if you didn't give that VAWA notification. Even if someone is not getting evicted because of domestic violence, if you are in those federally subsidized housing, the landlord needs to give that notice of VAWA rights if they're terminating their tenancy. If they don't, that's a procedural defense to the eviction, and the eviction should not be able to go forward. Next slide, please. And then, so say we got the eviction stopped, the next thing would be keeping that that subsidy. So first, request an informal hearing for the termination subsidy. When a housing authority is terminating your housing subsidy, you are allowed, or they're required to give you an informal hearing if you ask, but you have to ask. And so you would ask for that informal hearing and argue that they violated VAWA, because they clearly did. First, make sure they didn't provide the VAWA notice. They had to do that. And also, they are terminating the assistance because of abuse. Momo's presence on the property against Dottie's wishes was abuse. Momo keeping coming over there, they weren't living there. There is good case law explaining that it's not uncommon for an abuser to kind of force themselves to live in someone's property against their wills. That would not be an unauthorized occupant because it would be against their wishes. And the site is in the notes. Next slide, please. Oh, and yes, I guess that was the end. So that is a great ending to that. I thought there was another one. I'm sorry about that. So with those, this is a really strong case that someone should not have their voucher terminated and should not be evicted because of abuse. So I've mentioned multiple times that we have a lot of legal information and trainings on our website. Here is a list of some of them. We have a bunch more. Our website is password protected because a lot of our information is about how to help survivors of domestic violence get restraining orders and such. And we kind of don't want that to go to the people that are trying to harm them. So our website is password protected, but here's the password, and we have a lot of information and trainings on there.
Thank you, Taylor. And this is your contact info?
Yeah. So please feel free to reach out. We provide technical assistance to attorneys and advocates. We don't do direct legal services, but we do represent in appeals. So we provide representation in appeals, but not in trial court issues. But thank you so much for having us.
Thank you, and thank you for taking over when I wasn't feeling well. Much appreciated. And just want to remind folks that we are going to be emailing out the slides because I know some of you had difficulty with the link, and we provided a link in the chat to get MCLE credit for this training. And again, I just want to thank Taylor and FVAP and for sharing your expertise, and for all of you for participating. So thank you so much. All right, we're going to go ahead and end.